The Supreme Court just made a decision that ends Donald Trump's most important legal defense for good. This wasn't a close call or a split decision. What the justices did today, quietly and without argument, has fundamentally changed the course of American history. To understand why, we need to look back. Picture the year 1974. President Richard Nixon was under immense pressure, clinging to a powerful belief. He was convinced that the office he held placed him above the law, that his private communications were shielded from any court. He felt secure in this belief for one key reason. He had personally appointed 4 of the 9 Supreme Court justices. He saw those appointments as a transaction, a guarantee of protection. But on a July morning, that court delivered a unanimous 8-0 ruling against him. The justices he chose told him he was not a king and had to surrender the tapes. Days later, he was gone. For the past 3 years, Donald Trump has placed a similar monumental bet. He wagered that the modern Supreme Court, the conservative supermajority he helped cement, would treat him differently. He believed the transaction would hold this time. Today, that bet failed. The court issued a short, unsigned order. They refused to intervene. They denied his request for a delay. They have, in effect, pulled the emergency brake on his entire strategy of avoidance. So, what exactly did Trump's team ask for? Here's the critical detail. They didn't argue his innocence. They didn't claim he didn't do the things he's accused of. Their argument was all about timing and procedure. They claimed the very idea of prosecuting a former president was so novel and complex that the highest court needed to hit pause, for months, maybe a year, to consider it. The goal was never to win on the facts. It was to run out the clock. Push any potential trial past the November election. If he wins, he could make the case disappear. If he loses, he deals with it later. That calendar was his entire shield. Today, the Supreme Court took that shield and shattered it. By rejecting the delay, the court has sent the case rocketing back to the trial judge. The machinery of justice, jury selection, subpoenas, witness testimony, is now activated. And the most deafening part of this ruling? The silence. There were no public dissents, not from the staunch conservatives, not from the justices Trump himself appointed. Their unanimous refusal to step in is a roar of quiet condemnation. It signals that his legal argument for absolute immunity was so extreme, so detached from constitutional precedent, that not even his ideological allies on the bench could endorse it. They faced a choice: protect one man and undermine the court's own authority, or protect the institution. They chose the institution. This creates a catastrophic problem for Trump's defense. Without the shield of delay, he now faces the sword of evidence. Legal experts I've spoken to today agree. On the actual merits, with the tapes, the documents, and the public record, his position is perilous. His only viable defense was, "You can't try me." That door is now closed. And look at the new timeline. Instead of campaigning freely, he is likely to spend the coming months in a Washington, D.C. courtroom. He will sit and listen as his former closest aides may testify against him. The political and legal realities are about to collide in an unprecedented way. This moment also exposes a fatal flaw in Trump's worldview. He operates on a core belief that everything and everyone is transactional. He saw judicial appointments as delivered loyalty, a debt to be repaid. But he misunderstood the nature of the Supreme Court. These justices are institutionalists with lifetime tenure. They do not answer to him. Today, they demonstrated their independence in the starkest terms possible. You can sense the shock in the reaction online. The rage is directed at a corrupt system, but noticeably not by name at his justices. To attack them is to condemn his own judgment. So what happens now? First, the legal timeline accelerates dramatically. The trial judge, free from the threat of a high court pause, can and will move quickly. A jury could be seated within months. A verdict could arrive before Americans vote. Second, the calculus for every witness and co-defendant changes overnight. They were hoping for a pardon from a delayed process. Now, the path to a pardon is closing, and the incentive to cooperate with prosecutors to save themselves is soaring. When the flagship sinks, people scramble for lifeboats. Third, and most profoundly, this reshapes the 2024 election. We have never had a leading presidential candidate simultaneously standing a federal criminal trial. Trump's ability to control the news cycle will be hijacked by daily courtroom drama, not rallies, but evidence. The delay until after the election strategy is finished. The American people will now get information a jury hears in real time before they cast their ballots. Consider the alternative path for a moment. If the court had granted the delay, they would have handed Trump the ultimate gift, a chance for voters to decide without knowing if he is a convicted felon. By simply letting the normal judicial process proceed, by treating him like any other citizen, the court did the bare minimum. But in this climate, that minimum act is profoundly significant. It reaffirms a founding principle: the law's reach must include even the most powerful. This decision also sends a powerful signal to other judges overseeing Trump's cases. It stiffens the spine of the judiciary, indicating that creative delays and outlier rulings won't find a safe harbor with this Supreme Court. The ground has just shifted. We are entering a new, volatile phase. Trump, a man who defines himself by winning and control, has just lost command of the pace. Special counsel Jack Smith now sets the tempo. There's an old saying, "The wheels of justice grind slowly but exceedingly fine." Trump bet everything on the slowly part. He is now discovering the exceedingly fine part. The evidence, the facts, the law, they all matter now, and he must face them without his primary barrier. Historians will likely look back on this unsigned order as a pivotal inflection point. It was not a grand speech or a dramatic televised ruling. It was a simple denial. But that denial ensures a trial. It ensures a verdict. It ensures that the nation moves toward its next major decision with more truth and less obstruction in the light. The strategy of immunity through delay is over. What begins now is the trial itself. For Donald Trump, the reality of facing the law, not just fighting it in the abstract, has truly begun. The next chapter starts today, and it moves at the speed of justice. If you want to follow every critical development in this historic case, make sure you are subscribed. This story is accelerating by the day, and we will be here to break it all down. Before you go, if this analysis helped you understand the seismic shift that just occurred, please hit the like button. It directly supports our work here on Winds of Thought. Let me know in the comments, do you believe this Supreme Court decision ultimately strengthens or weakens public trust in American institutions?